The International Tribunal for the Prosecution of Persons Responsible for Serious Violations of International Humanitarian Law, committed in the territory of the former Yugoslavia since 1991. More commonly referred to as the International Criminal Tribunal for the former Yugoslavia or ICTY, is a body of the United Nations established to prosecute serious crimes committed during the Yugoslav wars, and to try their perpetrators. The tribunal is an ad hoc court which is located in The Hague, Netherlands. The court was established by Resolution 827 of the United Nations Security Council, which was passed on 25 May 1993. It has jurisdiction over 4 clusters of crimes committed on the territory of the former Yugoslavia since 1991. Grave breaches of the Geneva Conventions, violations of the laws or customs of war, genocide, and crimes against humanity. The maximum sentence it can impose is life imprisonment. Various countries have signed agreements with the UN to carry out custodial sentences. The final indictments were issued in December 2004, the last of which were confirmed and unsealed in the spring of 2005. The tribunal aims to complete all trials by the end of 2012 and all appeals by 2015, with the exception of Radovan Karadzic, whose trial is expected to end in 2014, and Ratko Mladic and Goran Hadžić, who were not arrested until 2011. The United Nations Security Council called upon the tribunal to finish its work by 31 December 2014 to prepare for its closure and transfer of its responsibilities to the International Residual Mechanism for Criminal Tribunals, which began functioning for the ICTY branch on 1 July 2013. The tribunal will conduct and complete all outstanding first-instance trials, including those of Karadzic, Mladic and Hadžić. It will conduct and complete all appeal proceedings for which the notice of appeal against the judgment or sentence was filed before 1 July 2013. Any appeals for which notice is filed after that date will be handled by the residual mechanism. Hadžić became the last of 161 indicted fugitives to be arrested after Serbian President Boris Tadić announced his arrest on 20 July 2011. History: Yugoslav wars and genocide. The former state of Yugoslavia was divided into separate republics, leading to a war that caused severe civilian casualties on all sides. When discussing the events of the 1990s, historians and sociologists have used the phrases war crimes and genocide to describe the actions of military leaders, especially those of Croatia and Bosnia. The term genocide is often controversial, and is separate in meaning to mass killing, because it implies the killing and displacement of an entire ethnic, national, racial, religious or political group. During the Yugoslav wars, the Srebrenica massacre became the most infamous systematic killing of a religious group on European soil since the Holocaust. More than 2,000 Muslim men, women and children were killed by Serbian troops. Coined after World War II by Raphael Lemkin and adopted by the United Nations General Assembly in 1948, the term has developed into one of the most crucial laws of international cooperation. In its brief history in international law, the understanding of genocide has helped lawmakers to create a reasonable method for prosecuting accused perpetrators of the crimes of crimes, as stated by historian William Shabas, which has led to the creation of tribunals such as the ICTY. Creation: United Nations Security Council Resolution 808 of the 22nd of February 1993 decided that an international tribunal shall be established for the prosecution of persons responsible for serious violations of international humanitarian law committed in the territory of the former Yugoslavia since 1991, and calling on the Secretary-General to submit for consideration by the Council a report on all aspects of this matter, including specific proposals and, where appropriate, options, taking into account suggestions put forward in this regard by member states. The court was originally proposed by German Foreign Minister Klaus Kinkel. By the 25th of May 1993, the international community had tried to pressure the leaders of the former Yugoslavian republics diplomatically, militarily, politically, economically, and, with Resolution 827 through juridical means. Resolution 827 of the 25th of May 1993 approved S. 25,704 report of the Secretary-General and adopted the Statute of the International Tribunal annexed to it, formally creating the ICTY. It would have jurisdiction over 4 clusters of crime committed on the territory of the former Yugoslavia since 1991. Grave breaches of the Geneva Conventions, violations of the laws or customs of war, genocide, and crime against humanity. The maximum sentence it can impose is life imprisonment. Implementation. In 1993, the ICTY built its internal infrastructure. 17 states have signed an agreement with the ICTY to carry out custodial sentences. 1993-94. In the first year of its existence, the tribunal laid the foundations for its existence as a judicial organ. The tribunal established the legal framework for its operations by adopting the rules of procedure and evidence, as well as its rules of detention and directive for the assignment of defense counsel. Together these rules established a legal aid system for the tribunal. As the ICTY is part of the United Nations and as it was the first international court for criminal justice, the development of a juridical infrastructure was considered quite a challenge. However, after the first year, the first ICTY judges had drafted and adopted all the rules for court proceedings. 1994-95. The ICTY established its offices within the Aegon Insurance Building in The Hague and detention facilities in Scheveningen and in The Hague. The ICTY hired now many staff members. By July 1994 there were sufficient staff members in the Office of the Prosecutor to begin field investigations, and by November 1994 the first indictment was presented and confirmed. In 1995, the entire staff numbered more than 200 persons and came from all over the world. Moreover, some governments assigned their legally trained people to the ICTY operation. In 1994, the first indictment was issued against the Bosnian Serb concentration camp commander Dragan Nikolic. This was followed on 13 February 1995 by 2 indictments comprising 21 individuals which were issued against a group of 21 Bosnian Serbs charged with committing atrocities against Muslim and Croat civilian prisoners. While the war in the former Yugoslavia was still raging, the ICTY prosecutors showed that an international court was viable. However, no accused was arrested. The court confirmed 8 indictments against 46 individuals and issued arrest warrants. Bosnian Serb and it Duško Tadić became the subject of the tribunal's first trial. Tadić was arrested by German police in Munich in 1994 for his alleged actions in the Prijedor region in Bosnia-Herzegovina. He made his first appearance before the ICTY trial chamber on 26 April 1995, and pleaded not guilty to all of the charges in the indictment. 1995-96. Between June 1995 and June 1996, 10 public indictments had been confirmed against a total of 33 individuals. 6 of the newly indicted persons were transferred in the tribunal's detention unit. In addition to Duško Tadić, by June 1996 the tribunal had Tihomir Blaskić, Dražen Erdimović, Zejnil Delalić, Zdravko Mušić, Esad Lanzo and Hazem Delic in custody. Erdimović became the first person to enter a guilty plea before the tribunal's court. Between 1995 and 1996, the ICTY dealt with miscellaneous cases involving several detainees, which never reached the trial stage. Some of the accused had been arrested and others surrendered to the ICTY. Accomplishments. In 2004, the ICTY published a list of 5 successes which it claimed it had accomplished, spearheading the shift from impunity to accountability, pointing out that, until very recently, it was the only court judging crimes committed as part of the Yugoslav conflict, since prosecutors in the former Yugoslavia were, as a rule, reluctant to prosecute such crimes. Establishing the facts, highlighting the extensive evidence gathering and lengthy findings of fact that tribunal judgments produced, bringing to justice thousands of victims and giving them a voice, pointing out the large number of witnesses that had been brought before the tribunal, the accomplishments in international law, describing the fleshing out of several international criminal law concepts which had not been ruled on since the Nuremberg trials, strengthening the rule of law, referring to the tribunal's role in promoting the use of international standards in war crimes prosecutions by former Yugoslav republics. Organization. The tribunal employs around 900 staff. Its organizational components are chambers, registry and the office of the prosecutor. The prosecutor is appointed by the UN Security Council upon nomination by the UN Secretary-General. The current prosecutor is Serge Bramitz. Previous prosecutors have been Ramon Escobar Salem of Venezuela, Richard Goldstone of South Africa, Louise Arbour of Canada, Eric Osberg of Sweden, and Carla Del Ponte of Switzerland, who until 2003 simultaneously served as the prosecutor of the International Criminal Tribunal for Rwanda, where she led the OTP since 1999. David Tolbert, the president of the International Center for Transitional Justice, was also appointed deputy prosecutor of the ICTY. Chambers encompasses the judges and their aides. The tribunal operates 3 trial chambers and 1 appeals chamber. The president of the tribunal is also the presiding judge of the appeals chamber. Judges. There are 20 permanent judges and 3 ad litem judges who serve on the tribunal. UN member and observer states can each submit up to 2 nominees of different nationalities to the UN Secretary-General. The UN Secretary-General submits this list to the UN Security Council, which selects from 28 to 42 nominees and submits these nominees to the UN General Assembly. The UN General Assembly then elects 14 judges from that list. Judges serve for 4 years and are eligible for re-election. The UN Secretary-General appoints replacements in case of vacancy for the remainder of the term of office concerned. On 21 October 2015, Judge Karmalagius of Malta was elected president of the ICTY and Liu Dakan of China was elected vice president. They will assume their new positions on 17 November 2015. His predecessors were Antonio Cassis of Italy, Gabrielle Kirk-MacDonald of the United States, Claude Jorda of France, Merin Fausto Pocar of Italy, Patrick Robinson of Jamaica, and Theodore Merin of the United States. Registry. The registry is responsible for handling the administration of the tribunal. Activities include keeping court records, translating court documents, transporting and accommodating those who appear to testify, operating the public information section, and such general duties as payroll administration, personnel management and procurement. It is also responsible for the detention unit for indictees being held during their trial and the legal aid program for indictees who cannot pay for their own defense. It is headed by the Registrar, currently John Hocking of Australia. His predecessors were Hans Holt Hewish of the Netherlands, Dorothee de Sampaio Garrido-Nij of the Netherlands, and Theo van Boven of the Netherlands. Detention facilities. Those defendants on trial and those who were denied a provisional release are detained at the United Nations Detention Unit on the premises of the penitentiary institution Hagglanden. Location: Scheveningen, located some 3 kilometers by road from the courthouse. The indicted are housed in private cells which have a toilet, shower, radio, satellite TV, personal computer and other luxuries. They are allowed to phone family and friends daily and can have conjugal visits. There is also a library, a gym and various rooms used for religious observances. The inmates are allowed to cook for themselves. All of the inmates mix freely and are not segregated on the basis of nationality, as the cells are more akin to a university residence instead of a jail. Some have derisively referred to the ICT as the Hague Hilton. The reason for this luxury relative to other prisons is that the first president of the court wanted to emphasize that the indictees are innocent until proven guilty. Indictees. The very first hearing at the ICTY was referral request in the Tadic case on 8 November 1994. As of August 2014, update, the tribunal has indicted 161 individuals, and has already completed proceedings with regard to 141 of them. 18 have been acquitted, 74 sentenced. 13 have had their cases transferred to courts in Bosnia and Herzegovina, Croatia and Serbia. Another 36 cases have been terminated either because indictments were withdrawn or because the indictees died before or after transfer to the tribunal. Of the 74 convicted, 51 were transferred to 14 different states where they served their prison sentences, excluding those whose sentences amounted to time spent in detention during trial. 50 have served their term, and 3 died while serving their sentences. Proceedings for another 20 indictees are still ongoing, 4 are in the trial phase and 16 are before the appeals chamber. The indictees ranged from common soldiers to generals and police commanders all the way to prime ministers. Slobodan Milosevic was the first sitting head of state indicted for war crimes. Other high-level indictees included Milan Babic, former president of the Republika Srpska Krajina, Ramush Haradinaj, former Prime Minister of Kosovo, Radovan Karadzic, former President of the Republika Srpska, Ratko Mladic, former commander of the Bosnian Serb Army in Anti-Gotovina, former general of the Croatian Army. Haradinaj's trial began at The Hague on 5 March 2007 and the closing brief was given on 23 January 2008. The final decision of the ICTY was expected in March 2008. On 3 April 2008, ICTY issued a public notice of the Haradinaj verdict, in which he was acquitted of all charges. The judge said much of the evidence had been non-existent against Haradinaj or at best inconclusive, but he complained of witness intimidation, saying some witnesses had not testified because they had been afraid. On 21 July 2010, the cases of UCK commanders Ramush Haradinaj, Idris Balaj and Lahi Brahimaj were reopened for trial. However, on 29 November 2012 all 3 were acquitted of all charges for a second time. The cases as of August 2014. Update. There are 4 ongoing trials. Goran Hadžić, Ratko Mladić, Radovan Karadzic and Vojislav Šešelj. Each case is in the process of judgment by the courts, with the cases for Karadzic and Šešelj due in late 2015. The case of Karadzic was brought to the public eye once again in July 2015 with the 20th anniversary of the Srebrenica massacre, which resulted in the deaths of as many as 8,000 men and boys by soldiers under the command of Karadzic. Controversy has played a part in the case of Šešelj, with one judge being disqualified in 2013 for having demonstrated an unacceptable appearance of bias in favor of conviction, which is in violation of Article 20 of the ICTY statute. Article 20 empowers the judges to ensure that a trial is fair and expeditious and that proceedings are conducted to allow for the full respect for the rights of the accused and due regard for the protection of victims and witnesses, infusing due process. Since late 2014, Šešelj has been in Serbia awaiting his verdict due to humanitarian reasons concerning his health. which has deteriorated over the course of the trial. 5 further cases are at the appeals stage: Todorovic, Perisic, Popovic al., Sajnovic al., and Tolomir cases. An additional 23 individuals have been the subject of contempt proceedings. Croat Serb general and former president of the Republic of Serbian Krajina Goran Hadzic was the last fugitive wanted by the tribunal to be arrested. On 20 July 2011,